A state Supreme Court chimes in and warns lawyers about defamation when they publicize allegations in their lawsuits. Hi everyone, my name is Wayne Pollack. I'm an attorney who helps other attorneys engage the audiences that are loyal to their firm's success, including their clients, their referral sources, their employees, and the media. In this video, the Texas Supreme Court tells lawyers, be very careful when you're publicizing allegations you're making in your complaints. I'm here in beautiful Philadelphia, Pennsylvania, and for the past 17 years, the Pennsylvania Supreme Court has had a case on the books called Bocchetto versus Gibson, or I should say captioned Bocchetto versus Gibson. In that case, it tells lawyers, as a matter of law, lawyers can be liable for defamation when they publicize, that is, when they send copies of complaints they filed to the media when those complaints contain defamatory allegations, which most complaints do. And the idea being that when you make those statements in court, you as a lawyer are protected from defamation by what's often known as the judicial proceedings exception to defamation, or the litigation privilege to defamation. Different jurisdictions call it different things. But as soon as you take those allegations out of the context of a complaint, of a demand letter, of court, and you put them in the media and use them outside the court for marketing purposes, you now are stepping outside of the protections of that exception or that privilege, and you are now subject to defamation concerns, or at least defamation claims, as a matter of law. For that reason, I've always advised Pennsylvania lawyers that I work with to not send copies of complaints, not send demand letters or other documents containing defamatory allegations directly to the media when they want publicity or when they're seeking publicity. Instead, I warn them to just tell the reporter to go to the docket, give them the docket number, or find a way for the document to land in the reporter's possession without you sending it directly to them. I've also warned lawyers that they have to be careful when they're writing press releases to not include defamatory allegations in the press release, and instead to make it clear that the allegations are allegations. And they can use magic words like "as we allege," "as the complaint states," "as we contend," to hopefully get around defamation claims. Well, the Texas Supreme Court, just a few weeks ago, at least as of the date of this video being published onto YouTube, came down and ruled in a similar fashion to what the Pennsylvania Supreme Court did 17 years ago and what other appellate courts and Supreme Courts tend to rule when it comes to this issue. The Texas Supreme Court, in a case captioned Landry's versus Animal Legal Defense Fund, held that lawyers could be liable, again as a matter of law, when they send copies of complaints, or in this case, a notice of intent to sue, to the media, and they include defamatory allegations in a press release regarding that kind of document. I will include a link to the Texas Supreme Court's decision in the notes or the description of this video, but the gist of it is that the Animal Legal Defense Fund, ALDF, wanted to sue Landry's under the Endangered Species Act for Landry's alleged mistreatment of animals that it was keeping at its aquarium in Houston and at a restaurant in Houston. So the ALDF sent a notice of intent to sue under the Endangered Species Act to Landry's. This was in mid to late 2016. But in addition to doing that, the ALDF put a press release on its website and sent the press release and the notice of intent to sue to various media outlets. And they got publicity for their efforts. Well, Landry's found out that they did this and sued for defamation. And it went back and forth in the courts, but it got to the Texas Supreme Court on a motion to dismiss. And the lower appellate court had ruled that the lawyer who had made the statements was protected from defamation because of what in Texas is known as the judicial proceedings exception to defamation. And the Texas Supreme Court said, no, actually, that's not the case. You're not protected from defamation when you as a lawyer take a document that contains defamatory allegations out of the context of court hearings and court litigation, arbitrations, mediations, and you now put it in the media outside of the court for publicity purposes. Furthermore, there is the allegations in the press release that were defamatory were deemed to be, again, defamatory because those allegations existed outside of a court proceeding, outside of a court document, and thus this is a double whammy because the ALDF and the lawyer could have been liable both for sending the notice of intent to sue to the media as well as the press release, because both documents contain allegations that are defamatory, or at least alleged to be defamatory, and that were not put into a court document and kept within the four walls of a court. So what does this mean for you if you are in Texas? Well, if you're in Texas, it's binding authority. Do not send copies of complaints to the media or notices of intent to sue to the media, and be very careful what you put in your press releases. If you are not in Texas, it's just another reminder that even though this case the posture was a motion to dismiss, so the lawyer will have factual defenses throughout the rest of the litigation, it still should be very clear to you that if you are wanting to publicize what you are putting into your complaint, if you want to publicize a lawsuit, you want to publicize a notice of intent to sue, you've got to keep in mind a couple things. One, do not send copies of complaints to the media directly, or copies of these letters that contain defamatory allegations or other documents containing defamatory allegations to the media directly. Find a way for the media to get those documents themselves without your involvement. And when you are writing press releases, be very careful. And if you want to include the allegations that you are making in your legal documents, you've got to make sure that you couch them as allegations, as we contend, as we allege the complaint states, and that will hopefully help you clear out any defamation concerns. If you have any other questions about how to engage the media in connection with your pending lawsuits and pending litigation, check out other videos on this channel or go to copostrategies.com. We have plenty of blog posts and resources that you'll be able to use in order to help you understand better how to ethically, strategically, and proactively engage the court of public opinion on behalf of your clients and hopefully avoid defamation concerns while doing so.